Okay, Daria, I think we're about to get started.
Great. Well, welcome everyone to our presentation on environmental risk management and commercial lending. Today, we're going to cover a quick comparison of different oversight agencies, their environmental program expectations, and some basic considerations for building your policy. There is a lot of ground to cover in a short amount of time, so I'm going to do my very best to keep it moving. But before we begin, I'm going to hand things over to Gary for some quick housekeeping items.
Thanks, Daria. I appreciate it, and good day, everybody. Again, my name is Gary Kulik, and I am the Marketing Director here at CREtelligent. I want to welcome you to today's webinar on creating a regulatory compliant environmental risk management program. We are thrilled to have industry veteran, my CREtelligent colleague, Daria Milburn, to lead us to today's session. Daria has over 25 years of experience as an environmental professional. During her career, she has performed hundreds of environmental site assessments. She's reviewed thousands of reports. She's helped banks, credit unions, and other lenders develop environmental policies and procedures, and she served as risk advisors to dozens of lending institutions. She has been very active in different industry trade associations, including the RMA, NAGL, EBA, among others, where she's lectured on various environmental topics. Before we get started, again, as Daria said, a couple of housekeeping items. We're scheduled for 45 minutes today. We'll take questions throughout the presentation using the Q&A feature at the bottom of your screen. You'll see it there. Submit your questions. We'll address the bulk of the questions at the end of the webinar because Daria does have a lot of material to cover. But we'll also be sharing a recording of today's session as well as the presentation material in an email later in the week after this session concludes. And then lastly, we also have two other sessions planned in August that build further on today's session. And we encourage you to register for those if you haven't already. And so with that, turning it back over to you, Daria. Thanks.
Thanks, Gary. All right, folks, let's get into it and hope that technology does not fail us. All right, so just for a quick overview for today, we're going to be talking a bit about environmental risk, the regulators that oversee the lending institutions, some assessment tools that are commonly used, how to establish a matrix, some program considerations, and then bringing it all together. Like Gary said, there is an awful lot of content. We're not going to be covering absolutely everything today, which is why we broke it up into 3 sessions. So please do, if you have more questions or you want to take a deeper dive, we'll be doing that in sessions 2 and 3 later on in August. So the one thing that's brought us all here together today is environmental risk. And what is that? So environmental risk is essentially the threat of contamination at a real estate property, not necessarily commercial, it could be residential, but the threat of contamination from the use, storage, handling, or disposal of chemicals at a property. There's potential liability that comes along with that. And so for known or potential conditions, there can be legal or regulatory liability associated with those properties. And what we want to focus on is how that can be managed and protect your institutions from that risk. There's potential financial obligations. So if there are cleanup or there are lawsuits, there will be an impact either to your client who may be the subject of that, or to you and your institution. And then finally, in the event of foreclosure, environmental risk encompasses the potential to affect the marketability, redevelopment potential, and resale of that property once you've foreclosed. So let's first take a quick look at our regulators. So the regulators, the FDIC, the OCC, the NCUA, and the Federal Reserve are the 4 that we'll be looking at most closely today. They all have issued guidelines, and they include provisions for some components in a program that include policies and procedures, risk review and analysis, training, qualifications of staff, collateral monitoring, loan documentation, foreclosure, vendor management, and program auditing. The guidance that I'll be discussing a bit today can be found at these links for the respective agencies. Also, before I advance, I think it's really important to bear in mind the dates that some of these were issued. The OCC has always been really good about updating and issuing updated guidelines, but the last time the FDICs were issued was in 2006, the Federal Reserve at a whopping 1991, and the NCUA in 2008. Okay, so what the heck does this all mean, right? So what I've done is taken a look at each of those buckets and compared what the regulators have stated in their guidelines against each other. And so this graph essentially shows you each regulator, which are color coded. So this green would be the OCC, then we have the FDIC, the Federal Reserve is in the lighter green, and then the gray is the NCUA. And so this just helps you graphically depict who has the most guidance in each of these areas. But to break it down, there are some areas where one regulator is a leader over the others. So for instance, the OCC is a leader in the policies and procedures, risk review and analysis, loan documentation, and vendor management portions, whereas the FDIC kind of takes the cake for the balance, and the NCUA follows behind the FDIC, kind of tying with them in a couple of areas because much of what's in the NCUA's guidance has actually been taken from the FDIC's guidance. The Federal Reserve is not a leader in any of these areas for any of the things that they expect in their programs. In fact, there aren't even anything that I would classify as a moderate requirement. They probably have fewer or no requirements than most. So as we break it down a bit, and I know this is an awful lot of words on a slide, so we're not really going to pick it apart, but there are different areas that I think are really interesting in each of these buckets. So I've broken it down and kind of put language that was similar from each regulator into these buckets and into the subcategories beneath them. And as you start to do that, it's really interesting how it falls out. I would say that the OCC, quite interestingly enough, is the only one that mentions a link between appraisal requirements and environmental risk. The rest of them do not at all. Again, OCC makes a pretty, at least moderate statement about asbestos and lead. There's very little guidance about asbestos and lead from the other three. Also, I think one thing that's important to note about the regulators is that none of them actually give any specific expectations on your matrix. They do indicate that they expect that you have a matrix, but they do not take it any farther than saying that. So just something to bear in mind, because that's one of the places that folks get caught up the most. And we're going to talk a little bit more about how to build a matrix later on in this presentation. I think it's also really interesting to look at the training component, because one of the biggest things about having a successful program is to have a strong training module. And so it's not just training of your in-house staff who are doing your review work or managing your department, but also communicating with your lines of business that they understand your programs really well. The FDIC makes some really interesting statements around qualifications of review staff and third-party engagement. The OCC and Federal Reserve don't really come out and say much about it, but the FDIC and the NCUA following behind do state that if you don't have staff with adequate qualifications to interpret the data that you have in front of you, that you should be seeking legal counsel, environmental consultants, or other qualified experts to advise you on what you're looking at. So that may not be on every report, but that could be on a few that come back, some phase ones that may come back kind of hairy, even some database reports that are difficult to interpret. If you're having difficulty understanding and you have to do a lot of research yourself to even get to the point where you're understanding it, it's best to bring in a professional that can help advise you. Collateral monitoring, the NCUA says quite a bit about collateral monitoring. None of the regulators actually state a frequency for which you should be monitoring your collateral in their actual guidance documents that we have analyzed. Foreclosure, again, FDIC is really a leader in talking about foreclosure. We're not going to go through and break down all of this, but essentially you'll see a common theme throughout the foreclosure discussions, and it's all around CERCLA and AAI, which is the all appropriate inquiry rule, and that's what drives the phase ones that are performed. OCC is the only one that makes a statement about vendor management. The FDIC, Federal Reserve, and NCUA don't really say much about how to manage your environmental vendors. And then the FDIC comes down to program auditing. So what we want to make sure, and what I want to help you do today, is build a program that will allow you to be successful, to be able to implement it easily, and to maintain consistency, which will always be key, because the more consistent you are, the more credible you are. I'm going to take a quick break here before we move on to the next session. Gary, have any questions rolled in?
Daria, yes, we did have one related to the matrix. Somebody was asking if the regulators actually have a sample matrix. They're putting one together and looking for some kind of guidance. Does any of the regulators have like a sample matrix?
Okay, well, we'll get to that a little bit later in the presentation, but the quick answer to that is no, the regulators stop short of giving you a sample matrix. We actually do have some sample matrices later in this presentation. I would also advise the best thing to do is if you're not sure where to start, always look at the SBA. They have designed a pretty good process that allows loans to quickly move and to quickly capture environmental risk and escalate where needed, and filter out things that may not be as high concern. So when we get to that portion a little bit later, we can talk about that some more. And if I haven't answered your question or given you what you need by then, we can also connect after the webinar and discuss it a little bit further. One other thing I would add about vendor management, while the OCC does make a statement about environmental consultants and managing your vendors, I'm pretty sure that most of your institutions have your own internal guidelines, either through your procurement company, your procurement division or not, but around third-party risk management and evaluation of vendors. So I would say that just because the regulators don't say it in their environmental guidelines, if it's applied to your business as a whole, always defer to what is the most restrictive and follow your institution's guidelines as well. So this is about balancing both of those, but what you want to make sure you do is that you, at the very minimum, are meeting your regulators' expectations, because they can and will come in and stop lending practices until you fix that, or at least put you on notice that you're at risk of having your lending stopped until it's fixed. And it is a real thing that happens in the world. I've seen it happen, and I've seen institutions have to scramble to rectify it. So you don't ever want to find yourself in that position. So what my best advice to you could be is, as you sift through some of these documents and some of these highlights, and again, I didn't take the entire document and break it down. I took the big pieces out of it for you all so you can see that. You want to make sure that you're at least touching the mark on these as a guideline for the bare minimum that you should be doing as you manage your environmental risk. All right, so I'm going to skip ahead now, and I hope I don't make you dizzy. But let's come down and talk a little bit about the environmental regulations that are behind the liability issues and driving what some of the regulators expect as a result. So environmental risk is a risk not just to your institution, but to your clients. And so as you evaluate your transactions, I think it's important to bear in mind that you're looking at what's going to affect you as an institution, but before it affects you, it affects your clients as well. So the liability is going to hit them first before it hits you. And if they take on a financial liability or a regulatory liability or a legal liability, it can affect their ability to repay your loans. So while it's sometimes easier and faster to just do a quick screening, that's not always right. and you want to do what would be best for you. Now you can go the far end and overanalyze, and then you'll never close any loans and you'll be scared of your own tail. And so we want to find a balance for you in between. So these environmental regulations come down to some of the biggest here. So CERCLA, which you might hear also referred to as Superfund, and at a very high level, it really pertains to the cleanup of uncontrolled or abandoned hazardous waste sites, as well as accidents, spills, or other emergencies that have happened to soil or groundwater or air at the property. The EPA will do their best to seek out responsible parties for any release and ensure their cooperation in the cleanup. But some of these sites have been abandoned. The responsible parties are no longer viable entities, and so therefore they kind of have fallen into a no man's land. Under CERCLA, there is a secured creditor exemption, which we're going to talk about in just a minute, also referred to as the lender safe harbor. Then we have our EPA all appropriate inquiry, and that is probably one of the most popular and biggest things that you've heard about, especially lately, as ASTM has updated their most recent standard for phase 1 environmental site assessments. The EPA all appropriate inquiry is essentially indicating that there's been a prospective purchaser has done their proper due diligence to look into the property's history, identify any risks that might have presented to the property in its past operations, its current operations, and then if there are recommendations to follow through on what could be there so that they understand the status of that property before they take title, so that if there is a known issue at a property before they take title, that they can document it and have it reported appropriately before they take on the liability themselves. So if there's a responsible party that could be located before they take title, that happens. Again, most commonly linked to this particular part of the all appropriate inquiry is the phase 1 environmental site assessment, which you'll sometimes see referred to as the ASTM 1527. And right now the standard is 13, but ASTM just released the 18 standard. Then the EPA, in a very unhelpful way, adopted both standards as adequate for all appropriate inquiry, and then quickly backed off of that after some industry feedback. And so now we're waiting to hear the EPA come out with their final ruling on which standard is going to be accepted as all appropriate inquiry. And then we have our Brownfields Revitalization Act. And so again, with that, brownfields properties are much like Superfund properties where they're very well documented. If you have a brownfields agreement come across your desk, they're going to look in. That's going to prove that they've done a level of investigation on the property, that they've really looked into that property's history, that they've identified the areas of concern on that site. And quite often you have a much more comprehensive overview of a property's environmental status if you have a brownfields agreement than if you don't. So it's not always something to be afraid of, especially because it's such a structured program like Superfund. Superfund involves an awful lot of public comment. And so you'll actually find there's a very good amount of information available online for sites that have been identified and fall into these programs. What should be your concern are the sites that do not? I'll touch on the CERCLA secured creditor exemption, and then Gary, I see some more questions rolling in. So if you need me to stop so you can throw them out there, I certainly will.
Yeah, Daria, we just have one comment. Someone can't see your full slide, but I did check in with some others, and they seem to view it okay. So in any event, we will be sharing the slides in the recording after. So if there's one or two of you that are having trouble with the video portion, we'll certainly send those out. But that was it for now, Daria.
Okay, great.
Thanks.
Yeah. All right. So the CERCLA secured creditor exemption was codified under the Asset Conservation, Lender Liability, and Deposit Insurance Protection Act of 1996, meant to shield lenders from liability that hold property as a security for debt. Under this exemption, lenders may be spared CERCLA liability in the event of foreclosure, provided that they do not take operational control. So you're not engaging or participating in the management of the facility prior to its foreclosure, and that you have a timely disposal of the facility so that you offload the facility at the quote earliest practicable commercially reasonable time on commercially reasonable terms after foreclosure. Wow, that's a mouthful and awful and an awful high bar to try to reach, because for any of you who have been in special assets or have worked with your special assets groups, the minute you have a property that potentially has been compromised, it is very difficult to resell it, and it's also very difficult to avoid operational control. So in that event, what you want to make sure when you are protecting your safe harbor is that you're engaging with the proper professionals, and in some cases you may need to engage with an attorney to ensure that you are taking the proper steps to preserve your liability protections. Now, that does not preserve the protections for a future purchaser, but they will be responsible for performing their own due diligence and understanding the condition of the property before they purchase it. It's also important to note that spared liability doesn't mean there's no cost to a lender. So regulatory agencies may require you to take actions to prevent further exacerbation of a condition at a property, or at least to maintain minimal safety standards. And I have an example here that's embedded in the presentation. I won't go straight to it, but I'll let you access that and take a look at it yourself. But lenders have been known to have to take steps to bring a property up to a minimum safety standard or to prevent further contamination while they hold title. There could be an industrial property that has a wastewater treatment facility on site. You can't just shut it down and hope the problem goes away. Things like that have to be managed. So there may be some continuing operational items that have to happen. And that's where you have to work very closely with your regulators, your attorneys, to make sure that you are protecting your institution from liability. But it doesn't mean you won't have to spend money until you resell that property. So some fun facts. Remember that we talked a little bit about the dates on some of these regulators' documents. I think probably the most fun of all of these facts is that the OCC, while they updated their document in March of 2022, they still reference the ASTM standard from 2005. So that is an extremely outdated standard and actually does not provide all appropriate inquiry. So you should be sure that if you are engaging and you're trying to achieve your all appropriate inquiry due diligence, that you are following the current standard. I think it's just a typo and oversight on their part. These issues are by no means easy to understand, and it's an awful lot for the regulators to keep up with on their own. But if you are an OCC bank, you might want to reach out to them and let them know that it may be time to update that reference. FDIC in 2006, it predates our existing ASTM standard. Oh, I said that twice. The Federal Reserve predates any phase 1 standard, and NCUA predates the existing phase 1 standard as well. However, FDIC and NCUA, I will say, while they predate the existing standard, they reference all appropriate inquiry. They don't reference a specific ASTM standard. All right, before I move on to the next section, any additional questions, Gary?
Daria, yes, there was one that just came in regarding the regulations. Do you know of any plans of any changes coming down? Again, some of them have not been updated in a while. Are you aware of anything like in the works that might change any of them?
I am not, quite honestly, and I'll tell you, it's a little, this is one of those areas that's a little frustrating. So, you know, we have the interagency guidelines for appraisals, and it really would be nice to see that the regulators can come together and have interagency guidelines on environmental risk management. It is not something that we have seen happen. And aside from the OCC updating their overall document, doesn't necessarily mean that they've updated their environmental piece, as we've seen with that reference to an outdated standard. So I am not aware of anything coming down the line, but you know, we can keep you up to date. If we do hear anything, by all means, we can let you know. And if anybody is on this call that does know that the regulators are planning something special on environmental risk, send a chat over to Gary in the Q&A and we'll share with the rest of the team. Anything else, Gary?
That's it for now. Thanks.
All right, fantastic. So let's cover some assessment tools. I think we're okay on time so far. So, so first of all, these assessment tools, a little bit of comic relief because this has been a mouthful lately. It's about early detection. It's about understanding as much as you can before it happens. And I always liked this cartoon because it seems like this is sort of how it goes in our world sometimes. We find out as it's happening or after it happened that there it is. So this is probably something that you all will be very familiar with. There's countless tools out there to help you evaluate risk. Which ones are the right ones for you? Sometimes, you know, folks migrate to certain ones. These are just a sampling of what is a bit available and probably the most basic and most commonly used. So we oftentimes see questionnaires as an initial pre-screen that's conducted with a borrower or the seller, a database report which searches public records that are related to environmental health, safety, chemical waste, disposal. And it's important, I think, with these databases to remember that no listings in a database doesn't necessarily mean a site is clean. It just means that something hasn't been reported to an agency. So usually these database reports are run in accordance with ASTM radii. Sometimes they're done on a tighter radius, depending on what the focus is. But overall, they give good information about things that have been reported, but very, very important to remember, because I'm sure that many of you who review these hear quite often that, hey, there's no listings in the database, but you have other information either in your questionnaire or through some other document that shows there is an issue. The database report is not the Bible for saying a property is clean. It's just for telling you whether something's been listed there or not. The record search with risk assessment. And this is a very useful screening document. It's referenced by the SBA. We're going to talk a bit about the SBA in a moment. That's the Small Business Administration. Many of you may do SBA loans in addition to your conventional loans. The SBA has this document, which is a mixture of, it's a desktop report that doesn't require any site visits, but it's a mixture of historical records, a database report, and a questionnaire. And it helps to evaluate whether there's been anything in the property's history that you should be aware of, or if there's been any listings from a regulatory database that you should be aware of, and that questionnaire. And if there is an issue, it's very straightforward. Either there's an issue or there's a no issue. If there's an issue, there's recommended next steps, and usually that's going to a phase 1 to look into it farther. In some cases, it can be a transaction screen, depending on what you're working with. Then the transaction screen, or the environmental transaction screen, or the transaction screen assessment, has all sorts of monikers. But this is done to the ASTM 1528 standard, and right now the current standard is the 14, although I do understand that ASTM is working to update the transaction screen standard as well. Not only does the transaction screen include everything that the RSRA includes, but now it includes an EP site visit as well. So you have trained eyes on the ground looking at your property. And then there's the mother of all environmental reconnaissance documents, which is phase 1 ESA. And this is the one that does the deepest dive before you start taking samples. So up until the phase 1, everything is all non-intrusive. So that questionnaire through the phase 1 ESA, that's all research, and it doesn't involve poking any holes or taking any samples at a property. It includes an in-depth regulatory file review, obtaining files from the regulatory agencies, a look into the historical, the history of the property, and again, you know, all the other things that were included in the previous iterations of reports. Again, when the phase 1 ESA is done appropriately and to the correct standard, you know, that's where the innocent landowner defense comes in. But the innocent landowner defense only comes in if you follow through on the recommendations from your consultant. So if there is recognized environmental conditions identified at a property, and somebody purchases or moves ahead with owning the property regardless and doesn't take additional steps to understand the status of the property after that, then there's a risk of forfeiting that innocent landowner defense. And then the phase 2 ESA, which includes the collection of samples at a property. And it could be samples of anything, but most commonly it's soil, groundwater, air. We also will see some ancillary intrusive investigations like asbestos and lead-based paint. But the phase 2 ESA is really designed to be performed once your recognized environmental conditions are identified. So a lot of times, you know, in my past, I'd heard my my borrowers come and say, it's a gas station. I know you're going to recommend a phase 2. Why don't we just go straight to a phase 2? And I'd have to say, whoa, stop. It's a gas station, but it might not have been configured the same way 20 years ago. The tanks might have been in a different place. It might have done auto servicing. And so there might have been service bays. So there's a lot of things we need to be looking at. And I don't know if I don't know the layout of the property. So I want to understand the property and its history before I go in and just start poking holes anywhere and taking samples. Just taking samples without a plan doesn't help. It's like going to the doctor and asking them to draw your blood. Just say, just draw my blood and take a sample, but they're going to ask you, why are they analyzing you? Why are they analyzing your blood? What is it that the concern is? They want you to do your well checkup first, and then they want you to come back or maybe go to a specialist, and then they'll draw your blood. So there's a whole process, and you don't want to just jump into a phase 2 without understanding what it is that you're looking at, what you want to test for, and what are the areas of concern at a property.
Daria, just a quick interjection, time check. We have about 13 minutes left, and we did have just a quick clarification. Somebody asked for clarify that the recent 1527 is 2021, and I think you had mentioned that earlier, the fact that there's 2 versions out there now, and EPA has got to act to recognize the 21 version as the final.
Yeah, and I believe what they're really going to do is go and adopt the 2021. They created an awful lot of confusion between the 13 and 2021 by saying they accepted either. But you know, for any of us who have been involved either in performing phase 1s or reviewing phase 1s, that's an awful lot of cats to herd when you start recognizing 2 standards. It's best to pick one and stick with it. There really isn't there isn't an excessive difference. It's just that the 21 requires the consultants to button things up a little bit tighter and apply more consistent terminology and a more thorough investigation. But it's not a significant, it's not an earth-shattering change, and it shouldn't be much more expensive to perform than the 13. So hopefully the EPA will come out soon. It wasn't ideal to see them backtrack, but for now the 13 is where it is. If you receive a report done to the 21, it just takes the 13 to a higher level, and so it probably wouldn't hurt, but it's not officially recognized, so there could be a semantics loophole if you do that.
Cool. And just a real quick update on the transaction screen assessment. That's set to be published this week, I believe. Somebody chimed in with that, so thank you. Great. Georgina.
Excellent. Love it. Thank you so much. Okay, now down to the heart of it. We're going to come to the matrix. So instead of, you know, I wanted to find a creative way to talk about this because there's so many pieces that go into creating a matrix. And I thought maybe a word map might help bring that into light. There's so many things that, you know, that can help you determine where your biggest risks lies. So you can look at, you know, your portfolio and analyze your portfolio. Are you noticing any trends in foreclosure? Do you notice that a certain loan amount, a certain loan range tends to be foreclosed on more than another? Or is it that there's, you know, a certain property type or property use that you find you're foreclosing on more than others? If you're noticing any trends, you might want to tailor your risk management on the front end to start screening those out better before they hit your books, and then you have to deal with them when they're in special assets or workout. So, you know, maybe that's one way you want to determine that, or maybe you're just more interested in having a simpler, just a very simple. Here's where we go. We have a loan of this amount, property use of this amount. What are we looking at? Do you lend in conjunction with other agencies? So are you doing USDA lending or SBA lending? What are their requirements? How do they influence you? What are your expectations around monitoring? Is your matrix easily implemented? Are you going to have too many questions? These are the sticking points. If you find that you have a lot of questions or that you're constantly issuing exceptions or waivers to your policy, then it might be time to revisit your matrix, because the more exceptions you do, the more you decrease the integrity of your program. And if you're compromising your program's integrity, it's going to be really difficult to maintain. So I believe we had a question about matrices. There's a lot of ways to skin this cat. And these are some sample matrices that I've come across over my many years in this field. And by no means are these exhaustive, and by no means are any of these particularly right for you, but they are a starting point from where some other institutions have been over the years. So you might look at this and say, okay, yeah, I'm really not worried about anything less than $5 million, or I want to break it up into loans less than $1 million, $1 million to $5 million, over $5 million. What does it look like for you? There are many ways that you can be looking at this, but starting with a quick matrix and putting down where your biggest concerns are a great way to go. I think that the SBA, like I said before, does it really well, where what you do is you start with looking at property uses, and anything that's considered a high risk industry immediately goes to phase 1, and everything else can start off with a record search with a risk assessment. And then you can use that to filter out anything else that needs a higher level of due diligence. Super easy, just a great way. The RSRA is a low cost way of doing screening. You could start with a database report. It really just depends on what are you looking for in your risk. What is your risk tolerance? How are you looking to manage this? So you can go all out and say you want a phase 1 on everything regardless. Well, you do that and you're going to make it really hard to close loans, and that's more of a risk elimination. And you're looking more at managing risk than eliminating risk, because let's be honest, if we were out there to eliminate risk, none of us would have jobs. There would be no reason to lend because there's always risk. So what level of risk are you willing to accept? And then that's probably the best place to start. And then use that jumping block from there. So if you don't want to require phase 1s on everything, what level of information do you feel you need to make an informed decision? It's all about your informed decisions. So, like I said, if you're not sure where to begin, start simple. Keep it simple. You want it to be easy to implement. The SBA SOP is a great place to start. This is a link to their entire document, but it's very intuitive. You can get right to the environmental section and follow their guidelines and build your matrix on their guidance. The more complex your matrix is, the harder it is to implement, the harder it is to be consistent. And you're going to increase your exceptions, which is going to decrease your program integrity. So if it's too difficult to understand, if your line of business can't follow it, then you're going to put yourself in a potential position where your regulators are going to be unhappy. Know your limits, and if there's any circumstances under which you wouldn't accept a property as collateral, be clear about that. Be clear all the way through. Keep your communications clear, because you will allow your line of business to better communicate with your clients. And that will help move your transactions along much easier. Oh, I have a blank slide. Okay, so now it's time for a moment of affirmation, brought to you by CREtelligent. First, risk management doesn't equal risk elimination. So don't always choose to avoid all risk. You just can't. And you also cannot account for risk management practices of other lenders, because you're always going to hear someone come to you and say, well, the client says that so-and-so bank or so-and-so credit union isn't going to make them do X, Y, Z. And I'm going to call shenanigans, because I've seen that happen more often than not. And the ultimate response to that is, your policy for your institution is your policy. And you cannot account for why another institution is willing to accept a certain level of risk. Oftentimes they're not really willing to accept that risk, and you're being told something that may not be 100% accurate. for what that other institution is requiring. I have personally caught borrowers in the midst of trying to tell me that other peer banks of mine had not required something that I was requiring. And a quick phone call cleared that up because the other lender was being told that I wasn't requiring the same thing. So it's funny to see how sometimes those games get played, but just be consistent and stick to your guns and don't sway. It's okay. It's okay to have a different policy. It's okay to have different expectations from somebody else.
Daria, quick time check. We got about 5 minutes left, and we do have some questions that came in. So just a heads up on that, if we could just leave a minute at the end.
Yeah, I think we can almost leave more than a minute, Gary, because I'm really about to close it up here. So this was just a moment of humor again, all about maintaining credibility. So on the topic of what other banks or other lenders or other credit unions are doing, we've all heard it. I've got an 8-year-old and a 14-year-old, so I can't tell you how many times I've heard what other parents do. And that's great, but I'm not those parents. So I want to maintain my credibility and I want my kids to know what to expect from me. So here it is. So some quick policy considerations. Remember your who, what, when, where, and why. We've always been told this. So let's look at that. Let's make sure that your policy document is being very clear about why you have this policy. What is your mission statement? What are your regulatory drivers? Who is responsible for owning and implementing the policy? What lines of business must adhere to what parts of your policy requirements? And what part of your position is responsible for tracking or monitoring your policy updates? What are you talking about in your policy? What are your definitions? What are your risk levels? What are your report types, your environmental terms? What is your policy matrix? Do you have criteria for acceptability? And what are your procedures? Outline all of that so it's in your document so it can be followed clearly. Document your when. What's your effective date of your policy? When was it last reviewed? When do you plan to have it reviewed again? And what were the revision dates of your policy? And where in the organization does this fall? And where physically can someone find your policy? Is it on your intranet? Are there credit resources that you have internally? Where can someone go to find that and easily access what it is you expect? So to establish your successful program, you want to define your risk tolerance. That's a topic we'll be talking about in our next webinar. Establish your matrix. Be ready to implement and take into consideration your stakeholders before you implement. If you're issuing a new policy or updates to your policy, understand how it's going to affect your stakeholders. Socialize your program, provide training. The more you communicate what you're doing, the easier it will be for you to implement. And then monitor. Are you finding that you have a balanced outcome? Are you issuing too many waivers? Are you finding that in collateral monitoring that you're finding that there's more concerns on properties than originally you identified? That may mean it's time to start screening a little differently. And other program considerations. So ultimately, regulators are looking for you to be adhering to your policy and implementing it consistently, that you have regulatory monitoring of your policy effectiveness. And if anything, you make sure you're always documenting your rationale for all decisions. And this really falls probably mostly on your credit officers than anything. But as you make your risk determinations, document your rationale so that it can be replicated and followed. If you come to a decision, but it's unclear how you got from point A to point B, the regulators are going to be really unhappy to see that, and they want to know that you followed a train of thought that was logical and justifiable. Looking at your vendors, managing their statement of qualifications, getting all their insurance documents, making sure that they have adequate insurance coverage, looking for possible semantics in their terms and conditions that could compromise. So if you have master service agreements, make sure that liability isn't limited to the value of the report that you've ordered, because if you order a phase 1 and you've paid $1,900 for it, and there's a problem, or the vendor made an error, or there's an issue, and you've incurred damages, and they say, well, you agreed that I'd only be liable for up to $1,900 in those terms and conditions, then you're really up a creek without a paddle. And train. The best you can do is train internally, train your line of business, train your staff, bring in subject matter training, continually educate and keep your communication going. So if we bring it all together, I think we just pretty much covered all of that, so I don't need to repeat this slide. It just looks fun with all of its gears. I guess the most important thing to bear in mind is that if you understand your expectations, you can make sure that you're meeting them. If your institution has a higher level of expectations, that's fine. But if your institution overall is a little more lenient, you want to make sure at the very minimum that you are meeting what your regulators are expecting in those documents. Okay, Gary. Oh, I'm 1 minute over. Is everybody good?
Great. Yeah, I was going to say, everybody, if we are at our 45-minute mark, just over it, if anybody has to jump, I certainly appreciate that. And but we do have a couple of questions here that we'll toss over to Daria here real quickly. First off, is it required for a phase 1 to include recommendations of further assessments?
Well, I mean, they don't require you to recommend additional assessment, but that is really up to the EP's opinion. So if additional recommendations, if additional work is necessary, then yes. Now, recommendations can be issued under separate cover or in the report itself. So if you prefer to have your recommendations under separate cover, that's fine. But it depends on what you're looking for. It isn't categorically required though for additional investigation. If there isn't any recommendations for additional investigation, then there's no recommendations to be made.
Great, thank you for that. Does the TSA, the transaction screen assessment, review adjacent properties within a radius search or just the subject site? And then same for the phase 1.
Yeah, so yes, so the ASTM has a radius that looks for different types of listings of different natures within certain distances from a property. So yes, both the transaction screen and the phase 1 do take into account surrounding properties out to the ASTM radii. And so if there are concerns at adjacent properties that are listed, it would come up in your regulatory database section of that report.
Great. Another one, we have two more, one regarding an SBA lender and another one regarding pre-screens, environmental pre-screens. Are those classified as a database report?
Oh, well, they take on all sorts of names. So yeah, I mean, it depends on where you're getting it from. I know our pre-screens are database style reports, but you know, if you're using a pre-screening tool and you're going through a vendor, I would ask them what is included in that pre-screen tool, what it comprises that document. A pre-screen could also be a questionnaire. So it really, that I would say the answer to that is it depends on where you're getting it from.
Great. And one last one here, and then we'll let everybody go. We are an SBA lender. There is nothing in the SOP that regulates who orders environmental reports. We are having lenders and customers push back that they should be able to order phase 1 and phase 2 reports. What are your thoughts on this?
So yeah, I think it's really hard to control quality if it's not centralized. All that being said, if you don't have adequate staff to manage an environmental risk department, then it is difficult. And a lot of institutions do have their line of business ordering reports. The problem is that if you have your line of business or your borrowers ordering reports that are not versed in what the SBA requirements are, then you could end up getting a report that is not sufficient for an SBA loan, and then you run the risk of having to go back and do more. And so having a centralized location where those can be ordered from, where you have a rapport with vendors, is helpful, but that's my personal opinion. You know, not every institution has the luxury of having, you know, adequate staff internally to order reports from one central location. So if you don't, then I would say this really depends on how your organization views this, and it should be something that then comes down as a decision by your institution. If you're housed under your credit officer, then it may just need to be that your policy designs it that it needs to be ordered from your credit, by your credit folks, or that it's ordered by processors. I'm not sure, you know, really that unfortunately you're right. And the SBA doesn't provide good guidance in that respect. But I think they're trying to apply to as many shapes and sizes of lenders as possible. So it's frustrating, but it's best if you can centralize it. And if you can't, then I think, you know, you have to really control your quality and be vigilant about your review process.
Great. Perfect. I think that'll do it. That's it for the questions. And again, great, very informative 50 minutes, Daria. I appreciate it very much and appreciate everybody joining us today. As I mentioned earlier, we will be sending out the material after this later on in the week via email. We'll send out a recording, the PowerPoint presentation, and then also a reminder to sign up for those 2 other sessions where we'll get a little bit more into how you formulate kind of your risk position, and then different tools and documentation methods. And with that, I'll move to close today's session. Again, thanks everybody for joining. And again, thanks to you, Daria, for a very informative 50 minutes. Have a good day.
Thanks, Gary. You too.